Good morning. You're probably wondering how we got to where we are here today, and how we got here is a product of games people play. I don't know if any of you read that book by Dr. Eric Byrne. He was the guy who was the... Sorry? Is that better? Anyway, we're here today because of a game that people play called Misery Loves Company. The county had a charter amendment which required ethics for them because of some issues that were going on, and Misery Loves Company, so now we're here today to solve the problems that they created. I'm here to talk about gifts and the rules that relate to gifts. Gifts are defined in Florida statute, and that's where you get the definition of what a gift is, and let me tell you what it is. For purposes of ethics in government and financial disclosure, it's anything accepted by a donee directly or indirectly, which is equal or greater consideration, where equal or greater consideration is not given within 90 days. It includes such things as real property, the use of real property, tangible and intangible personal property, the use of tangible or intangible personal property, the forgiveness of debt, transportation, airfare to New York. Food and beverage is probably the one that creates the most problem and is the most difficult to deal with. Membership dues, entrance fees, admissions, tickets, those kinds of things. Gifts do not include an award, plaque, certificate, or similar personalized item given in recognition of the donee's public, civic, or charitable or professional service. There's an exception in the Florida statutes. I refer to it as the Florida League of Cities exception. The gifts provided directly or indirectly by a state or regional or national organization which promotes the exchange of ideas between professional development and governmental officials or employees, and whose membership is primarily composed of elected or appointed officials or staff, to members of that organization or officials of the staff of that agency, is not a gift. That's the coffee you're getting here this morning. If the coffee were provided by a vendor or lobbyist or contractor and they had their name on the cup, that would be a gift which, under the rules, which I'll get to in a second, would be prohibited for you to accept without reimbursement of equal or greater value within 90 days. I believe Bobby said that you had a copy of the standards of conduct and the rules that were adopted by the county, and the standards of conduct are that in addition to the provisions of Chapter 112 Florida statutes, the following standards of conduct shall apply to elected officials. And the rules are fairly simple. Acceptance of gifts. Elected officials, their spouses, or registered domestic partners, their other relatives, and their county or municipal office staff shall not accept gifts directly or indirectly, regardless of value, from lobbyists registered with the governmental entity on whose behalf they serve, or from any principal or employer of any such registered lobbyist, or from vendors or contractors of such governmental entities. Elected officials may accept gifts from other sources given to them in their official capacity where not otherwise inconsistent with Chapter 112 Florida statutes, up to a maximum value of $50. The $50 limitation does not apply to gifts that were given to you in your personal capacity, not your elected official capacity. Such gifts are still to be reported under Chapter 112 Florida statutes. So it's important to know that the primary standard of conduct is that there are no gifts from lobbyists, vendors, or contractors. And so you need to know who they are. A contractor means a person having a contract with your municipality, and that could be most anybody that provides goods and services. A vendor is someone who provides goods and services or is a potential vendor, which is a difficult thing for you to do. to have to keep track of vendors and potential vendors. But a lobbyist is someone who's retained with or without compensation for the purpose of lobbying. It does not, the definition of lobbying is one sentence long. And it's a person who is retained with or without compensation for the purpose of lobbying, or a person who is employed by another person or entity on a full-time or part-time basis. The lobbyist does not include, now they spend 4 paragraphs talking about what lobbying does not include. Does not include an elected official, employee, or appointee of Broward County or of any municipality within Broward County communicating in their official capacity. It does not include an individual who communicates on his or her own behalf or on behalf of a person or entity in which they're a full-time or part-time employee, unless they're principally employed by that person an entity to lobby. Any employee or officer of a board of a homeowners association is not a lobbyist, as long as they're talking on behalf of something that affects their homeowners association. An employee or officer of a board of a not-for-profit corporation is not a lobbyist. That would include the Sierra Club, the NAACP, and the ACLU. So the rules are very simple, basically, that you can't take anything from a lobbyist, a contractor, or a vendor. But then the question becomes, what does that mean in the real world? If you get an invitation to a dinner, for instance, as part of the Florida League of Cities convention right here, and there are many of them going on, you need to know the name of the sponsor of that event. If the sponsor is on your city's list of lobbyists, vendors, or contractors, and I'm sure each of you has memorized the list of all the vendors and contractors and lobbyists for your city. If that's the case, you must pay the full value of that meal. If they're not on the list, it's okay to accept the $50 gift, up to $50, from other sources. In today's market, a rubber chicken dinner is usually less than $50. If it's over $50, you've got to reimburse within 90 days the difference between the value of the meal and the $50. Another example is you're invited to an event sponsored by the Greater Fort Lauderdale Convention and Visitors Bureau. That is an office of Broward County, Florida. Checking my list for the city of Fort Lauderdale, we have a number of contracts with Broward County, so Broward County would fall in the list as a contractor for the city. Therefore, you should not accept anything from the Greater Fort Lauderdale Tourist and Convention Visitors Bureau. And if you're invited to an event, you should reimburse them in their full capacity, unless it's as a member of that group you're going to whatever the event is as a member. The last example is the Chamber of Commerce invited you to a dinner where you will be awarded a plaque honoring your public service. The definition of gift, as I pointed out earlier, does not include plaques or certificates given in recognition of public or civic or charitable service. So the plaque is good to go. The dinner is another matter. Checking your list again, from memory I'm sure, of vendors, contractors, and lobbyists. The chamber is not on that list. Therefore, the value of the dinner is up to $50 can be accepted, and you have to reimburse over $50. If the chamber is on the list, you can accept the plaque, but not the dinner. There's one more thing to know, and there's a get-out-of-jail card called advisory opinions. If an elected official requests an advisory opinion from their municipal attorney, the attorney, based on the facts, as long as the facts don't change, can give papal dispensation to the acceptance of the gift or the attendance at the dinner. The exact word, the language is, any elected official may request an advisory opinion about how Broward County Elected Code of Ethics applies to his or her situation. Requests for opinions from municipal officials shall be made to the municipality's chief attorney or that attorney's designee. Requests for opinion shall be considered only in writing and signed by the elected official by his or her staff. And this is the get-out-of-jail card. If the elected official acts in accordance with the binding advisory opinion, the elected official may not be found in violation of the Broward County Code of Ethics. The opinion, although can be given, will not cover Chapter 112 Florida statutes or any federal or other state requirements. So that's the rules. The rule of thumb, and that would end my presentation, the rule of thumb is check the list, lobbyists, vendors, and contractors before you accept anything. Thank you very much.
I'm Don Lunny, and what happens when you take a vacation and come back and have a conference call with very bright individuals is you end up with conflicts and outside employment. And that's a little different of a conversation than the one that we've had here in the past during our previous training sessions. It's a little broad. And so rather than dwell on exact language, I thought that it might be appropriate to talk about themes because ethics laws are principally designed to protect you and to shield you from being put in a situation that perhaps you shouldn't be in, and almost always when you tell a constituent or you tell a fellow lawyer, I have an ethical concern about this, perhaps I shouldn't be doing this, it is almost always accepted with respect and sometimes admiration that, by golly, here's a person that's trying to do the right thing. So as a point of entry, I'd like to start kind of where Harry did, and that is on section 119, subsection C. And so if you would turn to that, we're going to look at the standard of conduct's language, which is only 4 lines long, and kind of go through it. And this language, as Harry said, states as follows. In addition to the provisions of Florida Chapter 112, Part 3, these standards, the following ordained standards apply. So the first thing as an elected officer that you do when you think about ethics is you now know that the county law is referencing state law, which is applicable anyway. And so let's kind of have a quick overview of state law on conflicts and conflicts of interest. The first is the definition found in state law, and it's a conflict of interest means a situation in which regard for a private interest tends to lead to disregard of a public duty or interest. The private interest tends to lead to a disregard of a public duty or interest. And this theme shows up in doing business with your agency, okay? And the rule that no elected official acting in your official capacity, directly or indirectly, can purchase, rent, or lease any goods or services from the government you serve. Another rule is unauthorized compensation. No public officer, employee, or local government attorney, or his or her spouse or minor child shall accept any compensation, payment, or thing of value which you know or have reason to know with the exercise of care is given to influence you. Can't accept anything having value that you know is being given to influence you. Unauthorized compensation. Misuse of position, another conflict, another prohibition, violation, it's another violation of the standard of conduct. You can't corruptly use or attempt to use your official position or any resource within your control to secure a special privilege, benefit, or exemption for yourself or others. Conflicting employment or contractual relationships. Conflicting employment or contractual relationships. You can't hold an employment or contractual relationship with any business entity or any agency which is subject to the regulation of or doing business with the government you serve. You can't have an employment or contractual relationship that creates a continuing or frequently recurring conflict between the private interests and the performance of your official duties. So the themes are always go back to the essential definition of conflict, which is private interest over the public interest. Here's an interesting one that we don't always dwell on, and this theme will show up again and again in the law. And it's the disclosure of confidential information, the disclosure of use of information. A current or former public officer may not disclose or use information not available to members of the general public or gained by reason of his or her official position, except information exclusively to government practices. So you can't use confidential information to benefit anyone. And all of you from time to time receive confidential information. So those are themes in the state law that are referenced in the county law in terms of standards of conduct. The next one in this section 1C that is highlighted by reference are chapters 838 and 839 Florida statutes. So how many of us have recently gone back and looked at those chapters to see what are the possible conflict or criminal activity in that case that could be triggered by those chapters? Well, let's take a look. Chapter 838 is bribery, misuse of public office. And the subjects are bribery, unlawful compensation, which is a form of compensation for an activity that you shouldn't be doing, corruption, official misconduct, disclosure and use of confidential criminal justice information, and bid tampering. And under bid tampering, to give you a flavor of what that means, this is section 838.22. Pardon? I know you don't. All I'm trying to do is just talk to you about themes of what might be ethics laws. And so later when you go, themes concerning ethical conduct, so when you go back to your offices, if you want to take a look at these provisions, you can. I don't mean to have you absorb all this in terms of the minutia. But bid tampering, it is unlawful for a public servant to influence or attempt to influence the competitive bidding process undertaken by any state, county, municipal, or district to disclose material information concerning a bid or aspects of competitive bidding when it's not publicly disclosed. And it's unlawful for a public servant with corrupt intent to obtain a benefit for any person or cause harm to another to circumvent a competitive bidding process. Another theme about when does the private interest interfere with the public one. Chapter 839 Florida statutes is titled Offenses by Public Officers and Employees. This has been part of our criminal code for a long, long time. And the ones that might be applicable, again, are misuse of confidential information. That's crime in our state. Then the next section that's referenced by 1C is the United States Code. And I think this provision will be more thoroughly dealt with Jacob. It involves honest services, it involves mail fraud, so I'm not going to spend a lot of time on it. And finally, it references Chapter 26, Article 5 of the Broward County Code of Ordinances. So the county ethics law that applies to municipal officials says, in addition to the rules that apply generally to county folks in our county code, these other rules will apply to municipal people. And when we review the Broward County law, there are some things in there that give you a bearing, so to speak, on what could be potential conflicts. And one is the intent. Essential to the proper operation of government is the commitment of its elected and appointed officials and government employees to independence, impartiality, and responsibility to the people they serve. To achieve this goal, it is necessary that government decisions and policy be made through the proper channels of government structure, that public office and employment not be used for personal gain, and that people have confidence in the integrity of their government. The public interest, therefore, requires that the law protect against any conflict of interest and establish standards for the conduct of elected and appointed officials and government employees. And then there's a kind of an aspirational list of standards of conduct. For example, under public trust, we serve the community. We consider the interest of the entire community in our decisions. We don't accept gifts or special considerations given to influence our vote. We will not use our public office for personal gain. We'll recuse ourselves from decisions when our personal or our relatives' financial interests may be affected. We disclose interest of impropriety to the appropriate authorities. We come to meetings prepared. We don't disclose confidential information without legal authorization. There's a whole list of aspirational statements that if you kind of go through them, it will give you a bearing on trying to make sure that you maintain the highest levels of integrity and that you don't put yourself in a position where by either disclosing information or voting or acceptance of gifts or doing any of the things that the other guys up here are going to talk about could be perceived as a conflict or a failure to abide by appropriate standards of conduct. Then lastly, I'm supposed to talk about outside or concurrent employment. And this is a creature which is both, or a concept that's both in the state law about doing business with your agency, could be voting conflicts that this subject arises, or it could be strictly within the county law concerning disclosure. And it says you can engage in employment consistent with your public duties, which we've talked about briefly, but you must disclose it on a form, and the disclosure has to be annually for municipal officials, and it has to disclose all remuneration that you receive. And there is, as we know, a short-term exemption for that. That if it violates a confidential provision of your current employment status, that your employer had the ability to file a sworn statement, and that would exempt you from disclosing remuneration until you next stand for re-election. So for some of you, I know that's coming up, and that exemption will be falling away by the mere passage of time. So I think that generally, when you think about ethics, you need to keep in mind the big picture and the themes that are impregnated in this subject, and think about whether anyone can possibly perceive your conduct as violative of one of these themes. And if the answer is, I think that it might be, then it's time to pick up the phone and talk to an advisor that will then get into the actual regulatory language of either federal, state, or local law as applicable. And please, please don't wait to have these discussions, because when you have them at a meeting and they're public, one, it stilts the exchange of information where the lawyer might want to ask questions and feels like this is going to be embarrassing if I dwell much further on this, and try to raise ethical concerns and ethical questions early and often. And finally, on behalf of all of us here, thank you for thinking about ethics, and thank you for your public service. It's a noble service. You should be proud of it. It's a privilege to be an elected official, and don't forget that. Thank you.
Good morning. I have the privilege of going over three components of the Broward County Code of Ethics, primarily the lobbyist provisions, the honest services provisions, and the provisions related to fundraising, both charitable and campaign contributions. But there's something that Don actually just alluded to that I wanted to just kind of reiterate and bring your attention to. We all up here can certainly try to educate you and provide you with the information and the tools that you need to go and do your jobs as elected officials. But at the end of the day, all we can do is offer advice. And if you have specific questions, and Jamie's going to get into this a little bit later, if there are ever specific questions that you need direct advice on a particular issue, at the end of the day, the only person that can give you real, true, insulating advice is your city attorney. So I just want to keep that in the back of your mind, that while all we can offer is certainly helpful and pertinent, at the end of the day, it's your city attorney that can really provide you with the binding, insulating advisory opinions that Jamie's going to talk a little bit about shortly. With regards to lobbyists, the first thing I just want to touch on is actually something that Harry had alluded to by way of definitions. And when you're looking at lobbyists, who is and who is not a lobbyist, and what is and what is not a lobbying activity is a real critical part of the analysis. Under the county's Code of Ethics, as Harry said, a person who's retained with or without compensation, whether that person is compensated, it makes no difference as to whether or not they're considered a lobbyist under the county Code of Ethics. So a person retained with or without compensation for the purpose of lobbying, or a person employed by another, full or part-time, principally to lobby. And the principally to lobby term is something we're going to talk about a little bit later. That's been a source of some question. When is a person retained principally to lobby on behalf of that person or entity? And the code provides 4 specific exceptions for individuals who are not lobbyists by definition. You all, elected officials, I know most of the people in the room are elected officials. An elected official, employee, or appointee of a city or a Broward County acting in his or her official capacity. So when you go and communicate on behalf of your respective cities, by definition, you are not lobbyists. You're not engaging in a lobbying activity. A person who communicates on his or her own behalf. When somebody speaks to you on their own behalf on an issue that is relevant to them personally, they are not a lobbyist. Or on behalf of a person employing that individual, unless that person is employed principally to lobby, and we see that term again. So if a person is communicating to you on behalf of their employer, they're not lobbying unless they are retained principally to lobby by that employer. An employee or an officer of a homeowners association or a neighborhood association, community association, that's communicating in such capacity only to the extent that when they're addressing an issue that impacts that particular association, those individuals, those officers, those employees of HOAs are not by definition lobbyists. And any employee or officer of a nonprofit public interest entity, and as Harry suggested earlier, the code actually provides 3 specific examples. There are others, but the ACLU, the NAACP, the Sierra Club were examples of those nonprofit public interest entities that are identified in the code. Lobbying activities, a communication by any means, and the key is really by any means. You can be lobbied by email. You can be lobbied over the phone. A lobbying activity is a communication by any means from a lobbyist to a covered individual. Now, a covered individual, that term doesn't appear anywhere else in the county code. That's kind of an awkward term that's been the source of some confusion that we've seen. So we're going to offer a definition of covered individual in a minute. But a communication by any means from a lobbyist to a covered individual regarding any item that will foreseeably be decided by a final decision-making authority when the communication seeks to influence the covered individual to support or oppose that item. It's a lobbying activity. But there are 2 specific exceptions, 2 types of communications from lobbyists that are not lobbying activities. A communication made on the record at a duly noticed public meetings, when a person gets up at a city commission meeting, speaks to you about an issue, even if they're employed principally to lobby by an employer. When they communicate on the record at a duly noticed meeting, they are not engaged in a lobbying activity. And the second exception is a communication from attorney to attorney representing the city regarding an imminent or potential judicial or adversarial proceeding against that city. And that's typically a communication between attorneys, not so much elected officials, but I do know there are some attorneys in the room, and that exception does apply. Now, this term covered individuals, which is only used in defining what is and what is not a lobbying activity. Everybody in this room, more likely than not, is a covered individual. City commissioners, elected officials, mayors, members of final decision-making bodies, oftentimes that could be a planning and zoning board, members of selection evaluation committees, even if they're making recommendations to a final decision-making body, city managers, city employees, all fall under this broad umbrella of covered individuals. And one thing to keep in mind is that this code does not apply by way of disclosure requirements and obligations on covered individuals. It only applies to elected officials. But all of these covered individuals come into play when determining what is and what is not a lobbying activity. But we've had questions as to whether or not members of the Planning and Zoning Board, if they're a final decision-making body, are they obligated to disclose? Not under this code. Now, the county does have the prerogative to adopt a code of ethics for advisory boards and appointed members as well. It hasn't happened yet. So under this code, even though covered individuals covers more people than are actually subject to the code of ethics, it only applies currently to you as elected officials. Most municipalities, and I'm assuming most of yours, have adopted a lobbyist registration system. The County Code of Ethics does not specifically say municipalities shall or must adopt a registration system. What it does say is it references lobbyists registered under that system. So it presumes that municipalities have a system. I know that the cities that we work with have all adopted lobbyist registration systems, and each city is taking the steps to ensure that the tools are in place for lobbyists to register and to facilitate compliance with the disclosure requirements of the code. The lobbyist provisions and disclosure requirements are broken up really into 2 phases, and it's based on where the lobbying activity occurs, whether it occurs at City Hall or more broadly on city property, any city premises, or off-site, off of City Hall, outside of City Hall, or at a coffee shop, at some other public place or private place, but not a city-owned property. But when lobbyists and their principals or employers who intend to communicate with an elected official for the purpose of engaging in lobbying activities on city property must complete the contact log. And we'll get into the components of a contact log. But in other words, when you as elected officials communicate with a lobbyist at City Hall or on city property, the burden is on the lobbyist to contemporaneously disclose that communication. When you communicate with lobbyists outside of city property, the burden is on you. So what we've suggested to all the elected officials that we represent or that we work with is to keep the communications to the extent possible at City Hall. Keep the burden on the lobbyist, and in those situations, you have no obligation by way of separate disclosure. As long as the communications take place at City Hall, the burden is on the lobbyist to complete the contact log for each elected official they meet. So if a lobbyist were to come to City Hall and meet with you and your 4 colleagues, they would need to complete a separate contact log for each individual that they meet with at City Hall, and that contact log needs to be filed for public inspection. Now, what that means essentially is made available on the city's website, filed with the city clerk and made available on the city's website. And the term filed for public inspection is actually defined in the code to include that objective. Now, the content log that must be completed contemporaneously with the communication needs to include the lobbyist's name, the name of the entity that has employed the lobbyist, name, person, entity for whom he or she is lobbying, each elected official with whom he or she is meeting, date and time of the meeting, and the specific purpose, the specific subject matter that's being discussed. And I know many cities are implementing systems where there's a computer terminal right outside of the city commission offices, and every time a lobbyist comes in to meet with the elected officials, they simply log into the computer terminal, and there's a data entry point for each of these specific items, and all the information is logged electronically, and it gets processed right through the city clerk's office all electronically. And in those instances, again, there's nothing that you as elected officials have to do separately, so long as the communications take place at City Hall. When the communications lobbying activities take place outside of City Hall, at Starbucks or a restaurant or your home, wherever it might be, they are okay. There's nothing prohibiting those communications, but when they occur off campus, so to speak, the burden is on you as elected officials to disclose those communications. The disclosure must be made within 10 days of the lobbying activity, but no later than any vote on the subject matter of that activity, of that communication. So within 10 days of that exchange, you need to fill out a separate disclosure form, which has been prepared by the county attorney's office, to disclose that communication. And again, that disclosure needs to be filed for public inspection, made available on the city's website. And in addition to the information on the contact log for the lobbyist disclosures, the name, the entity they employ, it also requires the location of the meeting, date, time, and again, the subject matter that was the subject of the communication. Those are the key provisions to keep in mind when you think about lobbying activities, and communications with lobbyists. You don't need to disclose communications with lobbyists globally, only when those communications are lobbying activities, when there's some effort by a lobbyist to influence or to convince you to vote in favor or against any issue that is either coming or may foreseeably come before you as an elected official for consideration. One of the things that Don touched on very briefly was honest services. And the Honest Services Act was actually a federal law. It's 18 U.S.C. 1346 that was first enacted in, I believe, 1988. It was a fairly broad federal law that said it dealt primarily with officials not engaging in schemes or an artifice to deprive another of the material or intangible right of honest services. And the law itself was actually struck down as unconstitutionally vague in 2010 by the Florida Supreme Court in the Jeffrey Skilling case, in the Enron case. And what the court has said was that fraudulent services to deprive another of honest services through bribes or kickbacks supplied to a third party has not been deceived. And what the court basically found was that only those portions of the Honest Services Act that pertain to bribes and kickbacks is still valid. So those are the key portion that's still in effect from a federal standpoint. And that translates back to Chapter 838 in Florida statutes, which Don had referenced, which deals with bribery, unlawful compensation. And one of the things that Sam is going to get into a little bit later by way of enforcement is that the Inspector General, who enforces the Code of Ethics, has an obligation to refer matters to the State Attorney's Office if there's a belief that criminal activity has occurred, or the U.S. District Attorney's Office. And it's typically those 838 violations or honest services violations to the extent applicable. Those are the types of matters that would be referred to the state attorney's office. The final component of the Code of Ethics that I'm going to talk to you about this morning pertains to the solicitation and receipt of contributions. And it's a twofold approach. There's first solicitation of charitable contributions, and then solicitations of campaign contributions and fundraising for other candidates, not for yourself, but when you engage in fundraising on behalf of other candidates for office. And it's clear that the Code of Ethics allows charitable contributions by elected officials. Solicitation of funds by an elected official for a nonprofit charitable organization is permissible, unquestionably, so long as there is no quid pro quo or other consideration for the action. The solicitation also must be disclosed, and the county attorney's office has prepared a form. It's available on their website. Those forms need to be filed for public inspection. So whenever you engage in charitable solicitation on behalf of a nonprofit, you need to disclose those types of communications, including the name of the charitable organization, any event for which the funds were solicited, and the name of any individual or entity that may have promoted the solicitation. You do not need to disclose every person that you contacted or that you communicated with to solicit funds. But if somebody communicated with you, if somebody asked you to participate and to raise funds on behalf of the organization, that person who promoted the solicitation needs to be included on the disclosure. You do not need to disclose, again, every person that you actually go out and solicit funds from on behalf of the organization. Now, city commissioners and elected officials, you cannot use city staff or other city resources in the solicitation of charitable contributions, or obviously in the solicitation of campaign contributions. But so long as staff and city resources, public resources are not used, there's no prohibition on the type of activity. Now, there are two exceptions to the requirements pertaining to charitable solicitations. The disclosure requirements do not apply when you engage in charitable solicitations on behalf of a charity or a fundraising event that is sponsored by your city. Now, what does that mean? When is an event sponsored by your city? And we know most municipalities have all types of partnerships and relationships with nonprofits. They often give money, participate in different events. If a sponsorship relationship actually exists between a municipality and a nonprofit organization, and you go out and raise money on behalf of that organization, you do not have to disclose that type of communication. But what we would suggest is that there be some formal commission action, whether it's a resolution or a motion or some action from the dais that specifically recognizes or identifies the sponsorship relationship between the municipality and the nonprofit agency. But so long as that step has been taken, the disclosure requirements for charitable solicitations do not apply. The other exception is the disclosure requirement does not apply to a city commissioner that's employed by a nonprofit agency when soliciting on behalf of that organization. So if you're actually employed by a nonprofit and as part of your job duties is to go out and solicit on behalf of your employer, those types of communications are not a disclosable event. There's no disclosure obligation when you raise funds on behalf of your employer. Now, campaign contribution fundraising is a little different. Any campaign finance disclosure that you currently must submit to the Supervisor of Elections, in accordance with the Broward County Code of Ethics, you also now need to file those disclosures with your city clerk, filed for public inspection contemporaneously. So the same time you submit any disclosure to the Supervisor of Elections, those same disclosures now also need to be filed for public inspection with your city. Now, elected officials who solicit campaign funds for other candidates, and that's local, state, or federal candidates, shall disclose the following. And again, this form has been prepared and provided by the county attorney's office. The name of any candidate for office for whom you are soliciting, the location and date of any event, if any, and the name and contribution amounts of any individual who provided contributions to you either directly or indirectly to the elected official for subsequent delivery to the candidate. On this form, when you go out and solicit on behalf of another candidate for office, you need to disclose everybody who gave you money, either directly or indirectly, for you to in turn turn over to the candidate that you were raising funds for. It's a little different than the charitable solicitation provision, because on this form you actually have to identify everybody that actually offered you funds to give to the candidate. And again, the same restrictions also apply where city commissioners can't use city resources or other city staff to solicit on behalf of other candidates. And campaign and political contributions may not be made, solicited, or accepted on any government-owned building. So those are the key provisions pertaining to the fundraising, both charitable and on behalf of candidates, as well as the provisions related to honest services and lobbyists. And with that, I'm going to turn it over, I believe, to Jamie to offer a little bit on advisory opinions and procurement.
Good morning. 2 weeks ago, I was reading an article by Mark Funkhauser. Mark Funkhauser is with the Governing Institute, and he's the former mayor of Kansas City and also a former city auditor. The title of the article is "Why Ethics Training is a Waste." And I'll tell you more about the article later. And I'm not saying that I agree with former Mayor Funkhauser, but to the extent that the former mayor is correct and ethics training is a waste, I do want to thank each of you for wasting some time listening to me today. I'm going to talk to you about 3 issues: the selection committees, advisory opinions, and training requirements. As to procurement selection committees, what the code says is that elected officials cannot be on selection evaluation committees in connection with any prospective procurement by the elected official's governmental entity. You can't participate or interfere at the committee meetings, you can't be on the committee, and you can't interfere or participate in selection committee members. So when it comes to who's going to be on the committee, you can't even say these are who's going to be on the selection committee. Now, it does not apply to cities that have strong mayors or to cities where the charters require participation. Now, that is something that the League of Cities Task Force pushed for and was able to obtain. So that means, since there is an express provision here that says that there's an exception if the charters require the elected officials to participate, if a city wants to, you clearly on this issue can have an amendment to your charter that would kind of opt out of this issue. Now, you may be able to do that as to other issues, but that's for another day. But as to this issue, you clearly are allowed to. It also does not apply to hiring decisions for direct reports to the city commission. So if you have a need to hire a city manager or a city attorney or something of that sort, you are allowed to have a member of the commission sit on the selection evaluation committee. It does not apply to anything outside of the procurement area. So if you are leasing land or if you're doing a development project, it also does not apply to that. It also just applies to where there's going to be a prospective procurement by your entity. So that would not stop a city commissioner from one city from sitting on a selection committee in another city for that city's procurement. Something that brings to mind is the recent RFP in the city of Miramar for solid waste that some of you may be familiar with. In that RFP, there was a selection committee, and that selection committee included people from cities outside of Miramar. Now, clearly, no elected official from the city of Miramar could have been on that selection committee, but technically, it does appear that it would have been okay for a elected official from another city to be on that selection committee. Now, what was on the selection committee was just staff-level people, and there were staff-level people from 5 different cities. But theoretically, you could have had an elected official on that. Now, that raises a whole other question of what would have happened if, say, City X put someone on that selection committee, then Miramar entered into the contract, then City X wanted to piggyback onto that contract. Interesting issue that has not come up. An issue that has come up in the same solid waste area dealt with the Resource Recovery Board, because the Resource Recovery Board was talking about trying to find a solid waste disposal company. And in that situation, if you, as you know, the Resource Recovery Board is made up of elected officials from various cities throughout the county. So if the Resource Recovery Board were to go through a process and then choose a disposal company that would then go to all the different cities to choose, there was a concern that effectively that Resource Recovery Board is acting like a selection committee, and then the members of the different cities elected bodies are on the Resource Recovery Board, and then therefore that city would not be able to have that contract. So there was an opinion given by the attorney for the Resource Recovery Board on that issue. That, of course, is not binding on any of the cities, but it is an interesting issue that had come up. Now, so why did this happen? Why do we have this prohibition? At the time that the county ethics ordinance was done, Broward County commissioners routinely sat on selection committees. That was something that they did, and I will tell you for most of the cities that I've been involved in, city commissioners did not usually sit on selection committees. So that is not something that was really an issue at the city level, but it was an issue at the county level. And there was a perception that by having a commissioner sitting on the selection committee, it politicized the process. There was also a perception that the commissioner would basically hijack the process and take over the committee because staff would be intimidated by having the elected official on the committee. So it's not so much an ethics issue as it is a practical issue, but it was put into the ethics ordinance nevertheless. As I've seen it, this provision has not had a major impact on cities. Most cities did not have city commissioners on selection committees, so it's not really a major issue for cities, but it is something that is in the ordinance. The second issue I'm going to talk about is advisory opinions. Now, this is something that the city task force really did push for. We wanted to have something so elected officials would know before you do something whether or not it's okay or not. Now, if we didn't have this provision, you'd basically be acting blindly. The question was who was going to do it. The Inspector General did not feel it was appropriate for him to be doing these because he effectively prosecutes, so he didn't want to give the advisory opinions. In other counties, the Commission on Ethics, when there's a county commission on ethics, will issue these opinions. Under the Broward County, we don't have a commission on ethics, so that couldn't happen. The county attorney could have done it, but the county attorney really didn't want to start issuing tons and tons of advisory opinions to every single city. So the default really was to let each city do that. So the way it's drafted is each city attorney is the one who drafts advisory opinions for each elected official. So how do you get one? You have to request an advisory opinion from your city attorney or your chief legal counsel or designee is the way it's worded. That means that anything you hear today, and consistent with what Mayor Funkhauser says, is really a waste because you can't rely on anything that we say. I mean, if we tell you something today and you rely on it, and then the Inspector General comes after you for relying on us, you're out of luck. Now, if you go to your attorney and get an advisory opinion, then you can rely on it. So I'm not saying you should just leave, but at the same time, anything that we are saying, you cannot rely on. Just keep that in mind. Now, the other thing that this does is it results in inconsistency. Now, one of the main reasons for this ethics ordinance was so you would have the same rules throughout the county, that the county commissioners would be following rules, that the elected officials in each city would be following the same rules. Now, you have 5 attorneys up here, and generally when you have 5 attorneys, you have 5 opinions. So what ends up happening is this, if you're in one of the cities that my firm represents, you may get an opinion that you can do certain things a certain way, but if you're in one of the cities that Sam's firm represents, you'll be doing something a different way. And if you're in Don's city or Harry's city, you're going to be having different rules. Now, in general, the big picture things, I don't think we're going to be giving different opinions on. But there are some small things, and I'll mention one in a second, where we may have disagreements, and then you can follow your city attorney, but you do not have consistency. You need to request an advisory opinion in writing, and it has to be signed by the elected official or office staff. Now so that means if you just call up your city attorney and say, I'm going to do this, is it okay? And he says yes, that does not protect you. It has to be in writing, signed, and then you have to get a written opinion back from the city attorney in order to rely on it. Now, one thing I think that our firms may have a little differing on is we have allowed electronic signatures, so that if an elected official sends an email with an electronic signature on it, we have accepted that from an elected official. And Sam, I don't think you guys are requiring actual signatures, right? We're approaching that subject. Okay. I know that issue had come up. But we have decided that, if you send us an email from the city email address and has your electronic signature on it, that is enough, or the commission secretary can do that as well. Now, the key issue is that the request for the opinion must state all material facts. So if you go to us and you say, give us a whole bunch of facts, except you don't tell us, that it just so happens that it's your brother, but you tell us everything else, that's a problem. In order for this to work, in order for it to be binding, you need to give the facts. So if so, then this is what the ordinance says. If the elected official acts in accordance with a binding advisory opinion, the elected official's action may not be found to be in violation of the Broward County Ethics Code. So if you've given all the facts and you follow the opinion, you cannot be found to be in violation of the Ethics Code. Now, you could be found in violation of state law or federal law, but as far as the Broward Ethics Code, this is a safe harbor for you. Now, keep in mind, this issue about disclosing all the facts is crucial, because if you get an advisory opinion and you rely on it, and then it turns out you didn't disclose something or you lied in order to get the opinion, that's not going to work. But this is an excellent tool for elected officials. And let me give you an example of how it really insulates you. Let's say that you're offered a $25 gift from a company, and you want to accept it, and you contact, you look at a list of vendors, and you don't see this company on the list. You accept the $25 gift. You don't go to your attorney. You just said, accept the gift. You didn't see their name on the list. Now, it turns out that company does business under a different name, and they really are a city vendor. And then the Inspector General comes after you for accepting a gift from a city vendor. You don't have a real defense. I mean, you can say, well, I tried, I didn't see him on the list, I didn't know. You'll come up with stuff, but you don't have that opinion. Now, let's do it the other way. Let's say you went to your city attorney, and you did a written opinion, and you asked, and you disclosed it, and you gave the name, and you come to me, I get it, and I give you the written opinion saying, Company X is not a city vendor. You can accept the gift because it's less than $50. And I am wrong. You're okay. So this protects you, whereas if you do it yourself, it doesn't protect you. So the result of that is that we've, at our firm, have done a lot of advisory opinions. We've done over 130 advisory opinions so far this year. It's an excellent tool, and it's something that you really should take advantage of, because it's really the only way that you can protect yourself. The third issue is ethics training, and that's why we're here today. You are required to have 8 hours per year of training on public service ethics, and new elected officials must have 4 hours within the first 120 days, and that counts towards the 8 hours. That's what the code says. Now, I will tell you, I've now been doing this for various cities. This is, I think, my 25th hour. So if you think 8 hours is a lot, 25 hours is even more. And there's a couple of issues here. The first question is, there's no definition of hour. How long is an hour? I mean, I assume you're saying 60 minutes. Have you ever had a massage? When you get a massage, an hour massage, 50 minutes. How about an hour TV show, 48 minutes plus commercials? My son just graduated from college. He took a 3-credit hour class. He would go 3 days a week at 9 o'clock, but they would let him go at 9:50 because he had to walk to his 10 o'clock class. So the classes were only 50 minutes. An hour is 50 minutes. When I got the bill and I said, look, it's 50 minutes, I should only pay 5/6. Say that didn't work. Most continuing education courses, for lawyers, for example, most continuing education requirements say that if you go to an 8-hour, one-day course, you get credit for 8 hours, even though you may only have 6 or 7 hours of actual training. This kind of reminds me of the story of the lawyer who dies and goes to heaven. He says, this must be a mistake. This is what he says to St. Peter. I'm too young to die. I'm only 50 years old. St. Peter raises his eyebrows and says, 50? According to our calculations, you're 82. How'd you get that? The lawyer asked. We added up your billable hours. So the bottom line is, an hour is not necessarily 60 minutes. So today you'll be here for 3 hours, from 9 to 12. We took a 15-minute break. We'll probably take another break. So you'll still get credit for the 3 hours. Now, I have not been asked that opinion yet, but I assume that I will be. And when I give that, when I'm asked that opinion, my opinion is going to be, and once again, you got to ask your own city attorney. But my opinion is going to be, if you go to something like that, that's 3 hours, you get credit for 3 hours, even though it may not actually be 180 minutes. Now, the other issue that is not defined is the definition of the word year. What is a year? Now, it could be you need 8 hours. When it says 8 hours a year, does that mean 8 hours every calendar year from January 1st to December 31? Well, let's say you have your elections in November. So someone's elected, at the beginning of November of 2012. Now, they need 8 hours a year. So does that mean they need 8 hours in 2012, so they have 2 months to get 8 hours? Or do you prorate it? You say, well, you have 2 months left in the calendar year, so you need 1/6 of 8 hours. So you need 1 hour and 20 minutes during 2012, then you'll need 8 hours in 2013. But remember, you also need 4 hours in your first 4 months. So now how is that going to work? Do we prorate that? So you need 2 hours in November and December, even though only 1.2 is required for all of 2012, and those 2 hours are supposed to count towards the 8. How do they count towards the 8 and if they don't? So anyway, it ends up being a complete mess if your elections are in November. If your election's in March, it doesn't really affect you so much because the four months are in the same calendar year. But we have been asked and have given the opinion to several cities who have November elections that instead of year being a calendar year, year can be calculated based on the election cycle. So the year goes from November to November. So if you're elected in November of 2012, you would need to have 8 hours between November 2012 and the end of October of 2013. You need 4 hours in the last 2 months of 2012 and the first 2 months of 2013, which will count towards it. And it really works a lot better if you have November elections to do it based on a November cycle. And once again, that's up to the city and the city attorney, and you would need advisory opinions. We've actually given advisory opinions that November cycle is okay. As far as implementation of the training requirement, different cities are handling this differently. Now, some cities are basically leaving it to the elected official. Under the ordinance, this is the elected official's responsibility. You're going to have to certify that you met the requirement, that you had your 8 hours. So some cities are saying, elected officials, it's up to you. Go to League of Cities, Florida League of Cities, go to Broward League of Cities, go to FAU, wherever you're going to go, do whatever training you're going to do, you're on your own. Other cities have done the opposite and said, we don't want you to have to worry about this. We're going to take care of it for you. So in those cities, which includes the cities where I serve as city attorney, we have done in-house training. We will do enough in-house training so if one of the commissioners doesn't go to any of the other ones, there'll be enough available in the city for them to do it. And that's really a decision that each city needs to make. So as far as this training requirement, having done 25 hours of it, it's my opinion that 8 hours is a lot of time to spend on this. I mean, Today, in the first hour and 15 minutes, we're going to cover everything in the Broward Ethics Ordinance. What you're supposed to do for the other 6.5 hours is an interesting question. In addition, the value of ethics training is questionable, and the Mayor Funkhauser, and let me read a little bit from this article because I think it's very interesting. Basically, in the mid-1990s, Kansas City was rocked by a wave of public corruption prosecutions involving elected city officials. So basically, in Kansas City in the mid-90s, there was a lot of issues similar to what we had in Broward County that triggered the Broward Ordinance. They created a commission. It was called the Red Flag Commission. And this guy, Mark Funkhauser at the time, was a city auditor. So he was actually on the commission. And he recommended, and the commission recommended, that they have required annual ethics training. So he was part of the people that proposed doing annual ethics training. He was a city employee. So after this took effect, he eventually found himself sitting, like you're sitting, in an ethics training. And this is what he thought about it. He says, "I thought it was dumb. Some of the stuff was interesting, and maybe the preaching would save a few souls, but most of it seemed to trivialize ethics. There seemed to be a mismatch between the serious crimes that had occurred and the response. It was as if ordinary city employees were being admonished not to take a city-provided pen home, and that showing up for work 5 minutes late was a theft of time. In seeking to catch sharks, it seemed to me, we had set our nets for minnows." And that kind of reminds me of the whole issue of city vendor, you not being allowed to accept a bottle of water from a city vendor. These type of trivial things where we're really missing the big picture. He then talks about what happened with the GSA in Las Vegas. You remember that conference that caused all those issues with GSA? They spent so much money and people were fired. Shortly before that happened, they had done ethics training and found that everything was okay in the GSA. And then he even talks about how the fact is what happened with GSA probably didn't violate any of their ethics laws. It was just stupid, something stupid to do. He then says, ambitious people in positions of power and privilege who are determined to exploit their positions are not going to be dissuaded by an ethics training program. And then he says, no system can provide a perfect defense against human cupidity, which is greed. I guess what his real point is that if a public official is going to be corrupt, and if they're going to take bags of cash from someone in exchange for the vote, does it really matter if they take a bottle of water? The point is, can you train people to be ethical? Or is really all we're doing up here is telling you some minor rules that you can't take a bottle of water from a vendor that really have no impact at all? Thank you.
Everybody still awake? Please at least try to look like you're awake. It's a good sign. You've heard some very important things this morning. I have a couple of preliminaries, and I welcome you all to Hollywood and to this conference, and for making the time and effort to actually be in this room this morning for several hours, which I know is not easy for you or for us to some degree, but it's an important aspect of what you are, what you do, and the very fabric of your elected consideration. So a couple of preliminaries if I can. I always try to open up a quick presentation to talk about history or about things that matter to kind of put you into the scope of why we're here. A couple of observations. On this day in history, by the way, on this day, August the 23rd, Louis XVI, who at the time was the King of France, was born. Of course, his end didn't end well. He was beheaded, as you may remember, some years thereafter. Gene Kelly, famous actor, as you know, he was actually born on this day as well in 1912. He was a dancer and a choreographer and an actor, and obviously we know him from Singing in the Rain and other musicals. In 1934, Sonny Jurgensen, who was a football player, you may remember, he played for what teams? Redskins, correct, and also the Eagles for a short time. Professional football player. He was born in 34 and also became a sports announcer. As a matter of history, though, affecting Broward County and Broward County history, today is also Mayor Jack Brady's birthday. Happy birthday, Jack. So Jack is no longer 60, just for your reference. He's 39, yeah, 39 and counting. Let's talk about the Inspector General's office and what it is that relates to the, I'm sorry? Yes. Say again? Who's? Pam Donovan's birthday also? She's somewhat younger, I believe. It's a good sign. A couple things. And I'm going to ask a very interesting question. Is there anybody here from the Inspector General's office today? Identify yourself. You can. It's okay. You're among friends. Feel free. Okay. Is there anyone who would like to out someone in the room who might be from the IG's office? I'd appreciate knowing that before I begin my presentation. It might be helpful. Apparently not. Okay, good. So we're among friends. Anybody here from the media? Any newspaper reporters or bloggers or others who might otherwise be interested in what we do today? Oh, Facebook? Be careful. Okay, so we have some preliminaries already set forth. We know a little bit about history. We're also aware of the fact that there is no media here, and for all intents and purposes, there's no one from the IG's office here as well. A couple of bits of history that relates to how we got to the IG and why we are where we are today. In November of 2010, there were 3 ballot questions on the referendum section of your ballot. There were 3 basic questions, one of which actually created the IG's office, what I'll be speaking about in a few moments, which supplemented and repealed, but then took over, as you may recall, that section of the County Ethics Code that had a reference to the Inspector General. As you may remember, the County Ethics Commission, which was created pursuant to county charter, essentially created an ethics code that we're dealing with today and dealing with forever in the future. Commissioner Vice Mayor Schechter was on that panel, and in that actual proposal to the County Commission was the actual segment for the Inspector General. But Commissioner Ritter and others put on the ballot a specific question which changed that, took it out of the code section and made it part of the Broward County Charter. The other 2 ballot questions on the ballot in November of 2010 were to impose the ethics code on constitutional officers and also to impose the ethics code on municipalities. Those are the 3 ballot questions, all 3 of which passed to whatever number that they did, but they all passed. So the IG's actual creation is sustained through the ballot question that occurred in November of 2010 and following. Have you all met the Inspector General? Raise your hand if you have. Please raise your hand. Okay. I happen to be on the selection panel, which I'll get to in a few moments, that actually selected the Inspector General because the Broward League of Cities was one of the 5 appointing members that got to sit on the selection panel and the qualifications committee, which is an ongoing organization currently in place today. What's the IG's job? Well, a couple things. Under the specifics of the county charter, and this is a charter provision. This is not in the county code of ordinances. It's in the county charter. He's an independent charter officer engaged for the express purposes set forth in the charter. What's he supposed to do? Well, he was essentially established pursuant to the charter referendum to investigate misconduct and gross mismanagement. Misconduct by the charter is defined as any violation of the state or federal constitution, any state or federal statutes or code, any county or municipal ordinance or code, or any conduct involving 3 things: fraud, corruption, or abuse. 3 key words. The second aspect, somewhat more global in nature, is the issue of gross mismanagement, which has become a buzzword for many of us in this room in the context of where there may be some interest on the behalf of the Inspector General as to behaviors, not just of elected officials, but also in the procurement environment, which we'll talk about as well. But gross mismanagement is also one of the aspects of the IG's responsibilities, dealing with the subject matter of material waste or significant mismanagement of public resources, which has become, again, a buzzword and a mantra for review by third parties in this day and age we have here. Who does the Inspector General have jurisdiction over? Where's the responsibility lie? This is a key factor in this discussion today. All elected and appointed officials, some here today are elected, some may be appointed, and employees of charter government, of Broward County, and of all municipalities, including any city, town, or village duly incorporated pursuant to the laws of the state of Florida. So it's a very global application. It doesn't apply just to elected sitting in this room. It applies to appointed members as well as to folks who are actually city employees. As Jacob Horowitz mentioned earlier, the County Commission will consider in the fall the ordinance which will apply the ethics code to city employees and to advisory boards, but at the moment that's not yet the case. But as to the Inspector General, it applies today. Be very clear about that. And again, the caveat that all of my colleagues provided today, in the event that you have questions, comments, concerns, observations, and misgivings, talk to your city attorney about those things, because quite frankly, in this vicinity of discussion, in this area that we're in, it's very important to have that conversation, because the IG provisions are applicable across the board right now. All entities and persons other than employees of the county, of municipality that provides goods or services to the county or to any municipality are also proscribed under the provisions of the article in the charter. So that applies to not just electeds and appointeds and employees, but also folks in the purchasing business, people who are selling cities goods and services. It applies to them as well. How does an investigation begin? Have you seen the tips line recently in newspapers and other publications? Investigations can be commenced by the IG if good cause exists and that an official, employee, or a provider, being again a contractor or vendor, has engaged in misconduct or gross mismanagement. So the Inspector General can actually initiate investigations without your calling him, without your calling a tips line, but independently. How does that get from point A to point Z? Well, I can tell you how it happens. It happens because, quite frankly, the Inspector General, like most folks in the investigatory business, they read blogs, they read newspaper accounts, and they read things that occur during their daily lives. So from the standpoint of their interest that can be tweaked from something such as a blog, that may serve as a premise for an investigation by the Inspector General. It happens in other venues as well, but in this particular case, it's not an improper venue to look at as a concept from the standpoint of gathering data to begin an investigation. However, the Inspector General may find good cause on his or her own initiative, the tips line being one source as well, but it's principally based upon, and this is an important factor, a signed, verified complaint stating allegations that, if true, would constitute misconduct or gross mismanagement. So when someone wants to file a complaint against anyone in this room or on this dais or anywhere outside this room, it's got to be a sworn complaint. And if it's a sworn complaint, that means that you're saying something under oath, which matters greatly, because for saying things under oath that are not true, there's the potential charge of perjury, which has a particular aspect to it that's not very pleasant. And be wary of it, be aware of it. So if someone wants to complain against you to the IG, it's going to have to be upon personal knowledge and sworn to as a sworn affidavit. The complaint may only serve as the basis for a good cause finding if it is signed by an identified person. There's no anonymity in a sworn complaint. You can't say John Smith or some other alias or some other nom de plume, so to speak. It has to be someone that's specific. Someone has to actually sign the complaint and make it known on the record what they're saying and how they're saying it. Because the declaration specifically says, under penalties of perjury, I declare that I have read the foregoing complaint and that based on my personal knowledge, that the facts stated are true. Very important that if someone complains against an elected official or an appointed official, it can't be because someone told me that that was the problem, or someone told me that they saw him taking bags of money, or someone told me that the vendor was bribing staff, or something of that type. It can't just be someone told me. It cannot be based upon hearsay. It's got to be based on what you know personally in the context of that information. Very important. You should also know that the Inspector General has certain powers that are inherent within the provisions of Article 12 of the Charter to subpoena witnesses, administer oaths, and require through the subpoena process, the production of documents and records to actually support the complaint as it may be. The Inspector General can also audit any program, contract, or the operations of any division, department, or office of the county or municipalities. That's the law today, irrespective of the fact that the county commission has yet applied the issue of ethics to city employees or to advisory boards. At the end of the day, this law applies at this very moment, and that means the procurement staff, contract staff, folks that work with vendors of goods and services. And what do cities do? They provide goods, and they provide a principally important set of services, but they also provide other things as well. And in the context of the IG's role and responsibility, he can actually audit existing programs today, can knock on the door, visit with you and your procurement staff, your city administration, and approach it from that perspective. The IG may also audit the operations or performance of any provider relating to the provider's contract for compensation with the county. Very important. Aside from the independent review of what's happening in City Hall, the Inspector General can be looking at things which are outside City Hall, which includes the providers that are providing the services or goods inside the building. Very important aspect. So, quite frankly, those who are vendors or who are contractors and involved in that process are obviously, they're within the same net, and they're certainly concerned about that from that perspective. If in fact a subpoena is issued, all officials, employees, and providers shall fully cooperate with the investigation. That's a given. No issue there. The IG has an opportunity to interview people and to basically review the matters at hand, and to the extent possible, IG staff will, and in fact the charter provision speaks to the issue, they can attend your meetings. They can attend public meetings. They can attend any meeting at which public business is undertaken under Chapter 286. In my opinion, I think my colleagues agree, it doesn't include meeting in the shade sessions, or in the context of labor or closed-door sessions. This is basically for duly known as public meetings. And to the extent that I'm personally aware, there are folks from those offices that do visit our city halls periodically, particularly during bid openings and other related activities where those kinds of behaviors that I described earlier might be of concern. Confidentiality. Section 112.3188, subsection 2, is amended about a year ago. A pending investigation of the Inspector General is confidential. So to the extent that you've read the newspaper lately, and there's been some commentary regarding the behavior and activity of the Inspector General not being busy, you don't know that. You can't know that. We can't know that, because, quite frankly, there could be 1,000 pending complaints under investigation today that are conscripted, that are basically privileged in the context of the statute that protects those investigations. Again, there may be more than meets the eye. We just don't know the answer, quite frankly. Malicious complaints. If the IG determines that a person has filed a complaint with a malicious intent to injure an official's or employee's or a provider's reputation with baseless, spurious, or false accusations, or with a reckless disregard for the truth of the allegations, the complainant, the person who filed that sworn complaint, thinking that it might have been a good complaint to file, shall be liable, not maybe, but the charter section says shall be liable for all costs incurred by the IG in the investigation of the complaint. There may also be an opportunity for the complainant who has filed such a complaint to be the subject matter of having to pay back, as it were, the cost and expense of the investigation, or potentially the prevailing party could potentially get attorney's fees as well, because in the theory of these kind of cases, you can't rely upon your city attorney to defend you. You cannot. You'll have to hire separate counsel, and if the complaint was filed with a frivolous intent or with a malicious or reckless intent to injure the reputation of you as a public official, and it's found to be that way, there's a premise to pursue attorney's fee collection from the complainant specifically. If the IG has a lot of, he's not a concierge, by the way, although one might argue that he's a referral source. Principally, the IG, as mentioned earlier by my colleagues, is in fact a referral source. If there's a criminal activity that's been investigated and reviewed, the IG has the opportunity and the obligation to refer the matter to the state attorney or to the federal office of the prosecutor as well in the U.S. Attorney's Office. If there's a Chapter 112 issue, an actual state law violation of ethics, that's a resource where the IG can refer his or her findings or recommendations. If there's an election law violation under the State Election Code, Chapter 98 through Chapter 106, in that situation, the IG can also refer the matter to the state for review by the Florida Elections Commission. And if there are other violations that would be jurisdictionally bound by other agencies, that also is a venue that the IG can act as a referral source specifically. I know time is getting short. A couple more things. The IG also can bring independent actions. If there's no other governmental agency that wants to pursue you, he'll do it himself. Be prepared for that. If there's no other state or federal agency that would otherwise capture the moment of the alleged violation, then there are hearing officers that are established pursuant to the charter section, which will essentially hear cases based upon a process and a hearing procedure that's set forth directly in the charter provision. Hearing officers are actually engaged by the county or engaged through the joint resource of the county as well as with the IG, and they have a whole host of obligations and opportunities. They're much like admin law judges in Tallahassee, but they have a jurisdiction, they have authority, they have specific obligations to pursue and to provide for the meting out of justice in the context of a complaint that might be heard. They also can issue final orders. And in the context of final orders, they have the force of law under the Charter, and they can be enforced in a court of competent jurisdiction. The standard of review is not beyond a reasonable doubt, just so you all know. It's basically a preponderance of evidence, which is a lesser standard, but one which is significant in and of itself. What can happen once there's a hearing and there's an activity that occurs? Well, the hearing officer can make findings and actually order fines, or can provide for a recommendation of a public reprimand or a censure of the public official in the event of violations. The cash potential, the cash penalties can be anywhere from $250 to $5,000 for each individual complaint, item within a complaint. So you might have 5 different components of a complaint. That would be potentially up to $5,000 per allegation. In determining the actual conclusion, as it were, the hearing officer is obliged to follow what is called the gravity of the violation, and whether it was an intentional act or whether it was even a repeat offense or was actually an honest mistake. And quite frankly, last I heard, none of us in this room are perfect, and for that purpose, unless you are, some of you may be, and if that's the case, that's great, but at the end of the day, that's not what the hearing officer is going to find. He or she's going to have to make a determination specifically as to how to handle that matter, one of the aspects of which is if you benefited by a specific act, the admin law judge, in this case the hearing officer, can actually make you what's called disgorge what you got, pay it back, restitution. That's also part of what can be ordered by the hearing officer. You all know what public reprimands or censures are. They're not pleasant. Congress does it periodically, aside from judging their own membership. To the extent that there is a finding that a public official has been in violation of the county ethics code as it's written, they can provide for a public censure or reprimand of the public official. Ultimately, the IG has to issue reports. One is due, I think, now. There's an annual report which is due. It should be coming out sometime shortly. Interestingly, you remember the movie The Shining with Jack Nicholson? Here is Johnny. Remember that little scene in the movie? Well, you get that little edge from the IG here in Broward County, because at the end of the day, once he or she is done with his work, there's actually an opportunity under the Charter to follow up, to make sure that what was determined to be a violation or a concern was actually handled. So from the standpoint of the section of the Charter, it's 12.01D4, the IG can follow up on any recommendations that he or she makes to determine whether such recommendations have been implemented. So by telling the IG, yeah, we fixed the procurement code last Thursday, we're not doing that anymore, that's not good enough, because there's an ongoing jurisdictional opportunity on behalf of the IG to get further into that discussion. A couple more things and I will close. There are certain costs involved in the context of the IG. As you know, under the Charter section, it's funded by Broward County government. There's a 0.25% opportunity against every public contract that the County Commission engages in. They get to select how that gets funded and paid. By my calculations, 0.25% of every county contract will raise about $1 gajillion. It's a lot of money from the standpoint of funding that office, and that's not a bad thing or a good thing, it's just a fact. But if you total up the potential allocation of dollars, that office will be funded very well for a good number of years to come. And because of that, their job and their allocation of their responsibility will not end as well. The Selection and Oversight Committee is an ongoing organization, just for the record. I was the chair when it was initially created, and I was on the panel that selected John Scott, who is an exceptionally qualified man. He has exceptional qualification, was the federal prosecutor for a number of years. I have met with him on several occasions. I'm sure you all have, as we discussed earlier. His intentions are clear. His intentions are set forth in the Charter, and his intentions are to be reckoned with by all of us in this room. This is not a situation that can be treated lightly or can be treated with a lackadaisical attitude, because these are serious provisions that have serious implications and repercussions for all of us in the context of our public life and being under a public floodlight on a day-to-day basis. In closing, let me suggest a couple things. As was discussed by all of my colleagues today, the advice that you would seek from your city attorney or local government attorney or that their designee does matter greatly. If there are issues or concerns or any matter of any sort that concern you in the context of your ethical behavior or the requirements under the county ethics code, the potential for the violation and the potential for taking further action by the IG are serious and are very important for all of us. Again, I thank you for making the time this morning. We look forward to having some good questions, and we'll hope to give you some good answers. Thank you all very much.